or media outlet by suing them for defamation or libel.
The New York Times, a supposed pillar of journalism, faces explosive accusations. They allegedly plotted for months with Blake Lively's team. Then, after promising Justin Baldoni's lawyers adequate time to respond to their damning article, published it hours early. Baldoni's team claims the Times acted with reckless disregard for truth, perhaps even knowing their allegations against Baldoni were false. This bombshell just flipped the entire defamation lawsuit, exposing calculated manipulation that could shatter public trust in media. The question isn't just reporting, but deliberate narrative shaping. Who knew, and what was their intent?
Casting them as villains and making them scapegoats for Lively's well-publicized media missteps.
The saga began with the New York Times taking an unyielding stance, painting Justin Baldoni as the absolute villain. They depicted him as the mastermind behind a sinister smear campaign designed to destroy Blake Lively's reputation after her accusations of misconduct at Wayfair Studios. This wasn't neutral journalism, it was a condemnation. The Times, a supposed beacon of objective reporting, cast Baldoni as a scapegoat, leaving no room for doubt. Their narrative left Baldoni's public image in tatters, fueling negative perception. But was it the unvarnished truth or a carefully constructed fabrication?
Parties orchestrated a retaliatory campaign to tarnish Lively after she alleged that Baldoni and Heath engaged in misconduct while shooting the film.
The New York Times didn't just report allegations, they actively joined Blake Lively's narrative, vouching for her claims. They presented accusations as if meticulously verified beyond doubt through their own investigation. This wasn't merely relaying information, it was an endorsement, a powerful media giant lending immense credibility to one side of a contentious story. Baldoni's team claims this transformed the Times from reporter to advocate, crossing a critical line from impartial journalism into insidious, defamatory territory. The damage was immense, and the Times knew it.
And video echoed and compounded the baseless accusations made by Lively and her co-defendants, the Lively parties, about the Wayfair parties and falsely accused them of having waged a smear campaign.
It wasn't until Justin Baldoni's lawsuit took shape that the New York Times reportedly grasped the gravity of its own missteps. The newspaper, previously seemingly untouchable, suddenly faced a formidable opponent in Baldoni's legal mastermind, Brian Fredman. They realized that without his intervention, their misleading narrative would have solidified public perception. This was a tipping point, forcing the Times to confront consequences of aggressive reporting and apparent abandonment of journalistic neutrality. But by then, the reputational harm was already extensive.
Admittedly, based its article and video on its reporter's review of thousands of pages of documents and expressly credited Lively's claims, framing them as having been verified by the New York Times' own investigation.
Brian Fredman wasted no time unleashing his counterattack, meticulously highlighting the New York Times' alleged egregious errors. He argued the Times didn't just act recklessly, it actively participated in defaming Justin Baldoni's character. By explicitly vouching for Blake Lively's claims, the Times transcended reporting bounds, presenting allegations as undeniable facts. Fredman's argument was clear. The newspaper acted with malicious intent, knowingly presenting false information in the most damaging light. This was no careless slip-up. It was a calculated assault on Baldoni's reputation. The stakes were impossibly high.
He's saying, hey, it just wasn't fair. And we're going to get into the part where Brian Friedman argues, you gave us a couple hours to respond. We scrambled, and you still published it before we could even get our response.
This wasn't mere careless journalism. It was, according to Fredman, calculated manipulation. By aggressively backing Blake Lively's version of events and presenting it as verified truth, the New York Times created the false impression that its own investigation had substantiated her claims. Much of what was published allegedly lacked rigorous journalistic verification to stand up under legal scrutiny. This went far beyond reporting. It was a deliberate attempt to shape the public narrative to fit a specific damaging agenda. The integrity of their process was now under intense fire. What was the real story?
Its salacious article well before TUI contacted the Wayfair parties the night before publication for quote-unquote fact-checking. After the New York Times' months of plotting with the Lively parties, the Wayfair parties got hours to respond.
The legal battle escalated when the New York Times filed a motion to dismiss, attempting to throw out Justin Baldoni's defamation lawsuit before it could gain real traction. Brian Fredman, not one to back down, met this challenge with an equally potent legal counterargument. His core focus, the New York Times had irrevocably forfeited its fair report privilege. This legal shield protects media outlets reporting on public concern, but Fredman argued the Times overstepped, transforming themselves from neutral reporters into active proponents of a damaging narrative. The fight was now squarely in the courtroom.
New York Times complains of group pleading, claiming it cannot tell the allegations against it from those against its co-conspirators. Of course, it is premature to require the Wayfarer parties to specify the acts taken by the New York Times in connection with its scheme with the Lively parties.
The fair report privilege is critical for media outlets, safeguarding them when they faithfully report on public legal proceedings. Brian Fredman argued the New York Times brazenly abandoned this shield. They didn't just report on Blake Lively's claims, they presented them as absolute fact, asserting they had been substantiated through their own investigation. This was a crucial distinction. By framing Lively's accusations as verifiable truths, the Times, in Fredman's view, shed any protection under this privilege. It wasn't just a minor oversight, it was, he claimed, a profound breach of journalistic ethics. The consequences were severe.
Jury will determine the truth based on the evidence, but the Wayfarer party's allegations are clear. The New York Times argues New York bars 2 California tort claims, but as the Wayfarer parties suffered damages in California, where nearly all make their personal and professional homes, they may bring claims under the law of California.
A pivotal strategic maneuver by Justin Baldoni and the Wayfarer parties is their insistence on applying California law instead of New York law. They argue defamation and harm predominantly occurred in California, where they live and work. This isn't just a technicality, it's a game changer. California law is famously more protective of individual rights in defamation and false light cases, offering broader protections and making it easier to recover emotional distress damages. This contrasts starkly with New York's less favorable legal framework. The choice of law could dramatically sway the entire case.
Based New York Times insists it is entitled to New York law no matter where their harm was felt. But California law remedies harms suffered in California by California residents.
Under California law, the potential for recovery is significantly higher. Plaintiffs can more easily claim emotional distress damages in defamation cases, a critical avenue for financial remedy, far harder to achieve under New York law. This means Justin Baldoni could potentially secure more substantial compensation if the case proceeds under California's jurisdiction, not just for reputational harm, but for the profound personal toll of the alleged smear campaign. This strategic choice bolsters Baldoni's claims, making it easier to demonstrate harm and secure meaningful damages. The stakes for the New York Times just skyrocketed.
California or New York law, the Wayfarer parties have stated a claim for defamation against the New York Times, even under the actual malice standard. The New York Times contends that the article and video merely reported facts, and thus the New York Times is shielded by the fair report privilege.
Unsurprisingly, the New York Times, headquartered in New York, vehemently opposes California law. Their legal team contends New York law should govern the case, asserting alleged defamation occurred through its New York-based publication, regardless of where individuals reside or conduct professional lives. This creates a sharp legal conflict between the two states, each with distinct rules and standards for defamation cases. The outcome of this jurisdictional dispute is paramount. If New York law prevails, Baldoni's team would face a significantly tougher challenge with less favorable protections for individuals claiming harm. This legal wrangling is fierce.
Your defamatory statements affect my client specifically in California. And you know, this modern world we live in with the internet really makes it that you're damaged no matter where the defamation takes.
At the heart of Brian Fredman's argument is actual malice. This high legal standard requires a plaintiff, especially a public figure like Justin Baldoni, to prove the defendant published false information, either knowing it was false or with reckless disregard for the truth. It's a formidable hurdle, but if proven, it unlocks the path to damages despite the high bar for public personalities. Fredman's strategy demonstrates the New York Times crossed this line, moving beyond mere negligence into deliberate or profoundly reckless falsehoods. The entire case hinges on proving this crucial element of intent.
Times has long presumed itself beyond accountability. Not here. The New York Times went past merely reporting on plaintiff Blake Lively's California civil.
Fredman's argument for actual malice centers on damning claims that the New York Times either knew Blake Lively's accusations were false or acted with profound reckless disregard for truth by failing to properly verify allegations. He points to instances where the Times allegedly selectively presented evidence, framed unverified allegations as confirmed facts, and deliberately omitted crucial context that would have seriously challenged Lively's narrative. This, Fredman contends, demonstrates a shocking disregard for journalistic rigor and ethics. The implication is clear. The Times wasn't seeking truth, but solidifying a predetermined, damaging story. The evidence is mounting.
For the veracity of its false narrative. The fair report privilege the New York Times seeks to hide behind does not protect it from liability.
Crucially, Fredman contends the New York Times had access to numerous documents and communications directly contradicting Lively's allegations against Justin Baldoni and the Wayfair parties. Yet, despite possessing exculpatory evidence, the paper allegedly chose to deliberately ignore it. Instead, they published a glaringly one-sided story, explicitly portraying Baldoni as the villain. Fredman argues that by willfully running this false account despite clear contrary evidence, the Times demonstrably acted with actual malice. This was not objective reporting. It was, in his view, a calculated effort to advance Lively's narrative while devastating Baldoni's reputation. A dark picture emerges.
Maliciously colluding with Lively and her cohort to publish a false and defamatory hit piece about the Wayfair parties.
One of the most striking aspects of Fredman's argument against the New York Times is his claim the media giant actively manipulated the narrative by selectively using text messages and other evidence. He asserts the Times took these documents and texts wildly out of context, splicing them together to deliberately create a false impression of events. The published article, according to Fredman, was a one-sided view, heavily reliant on Lively's allegations and framing them as unequivocally verified facts. This, he argues, goes far beyond reckless reporting. It's a deliberate attempt to mislead the public and sway opinion against Justin Baldoni. The depths of this alleged deception are profound.
Also states claims for false light, promissory fraud, and breach of implied in fact contract.
Adding another layer of damning evidence to the lawsuit is the allegation of promissory fraud. The New York Times, a powerful media entity, reportedly made a clear, explicit commitment to Justin Baldoni and his associates. They would have sufficient time to respond to the explosive article, specifically until noon on December 21st, 2024. This seemed a reasonable agreement, given the immense gravity of accusations. However, the Times, in a highly questionable move, allegedly broke its word. This broken promise became a key point of contention, exposing profound lack of good faith and raising serious ethical questions. The betrayal was palpable.
That the New York Times conspired with Lively, Reynolds, Sloan, and Vision PR to advance a false and defamatory narrative concerning the...
Instead of honoring their commitment, the New York Times allegedly published the damaging article and its accompanying video hours before the agreed-upon deadline, specifically at 7:11 a.m. Pacific Standard Time. This premature release left Justin Baldoni and his team scrambling frantically to respond within an impossibly limited window, drastically undermining any opportunity for a fair and balanced presentation of their side. This wasn't merely a logistical error. It suggests a deliberate attempt to push a one-sided narrative, making it impossible for the accused to mount a meaningful defense before defamatory claims went public. The fairness of the reporting process was utterly compromised. What was their rush?
Wayfair parties engaged in sexual misconduct towards Lively, and 2, allegations that the Wayfair parties orchestrated a retaliatory smear campaign to damage Lively's image and reputation.
Further evidence suggesting bad faith emerges from the claim that the article and video were apparently ready-to-go traps days before the New York Times even bothered to contact the Wayfair parties for their response. This suggests the Times had already decided the story would drop, irrespective of any feedback or corrections from Justin Baldoni's team. This pre-planned publication, coupled with the broken promise and premature release, paints a damning picture of the Times' intentions. It strongly implies that their outreach to Baldoni was a mere formality, a superficial gesture to feign journalistic diligence, rather than a genuine effort to ensure accuracy. The credibility of the Times is now in question.
This is one of the problems that does exist when it comes to news organizations, is you want them to be protected so they can't just have malicious people come after them if they don't like their report.
Adding a chilling layer to this tangled web, commentator Lady C, who has closely monitored the case, asserts this goes far beyond biased reporting. She alleges a deliberate, coordinated effort between Blake Lively and the New York Times to systematically damage Justin Baldoni's reputation. According to Lady C, this wasn't an isolated incident, but part of a larger orchestrated smear campaign, with the Times acting as a willing accomplice in propagandizing on behalf of the Reynolds and their cohort. Her perspective introduces the alarming possibility of active collusion, transforming a media outlet into a weaponized tool against an individual. This is a game changer.
fair. They got to at least try to tell both sides of the story. Or do they not? We'll find out.
Lady C's perspective emphasizes profound sympathy for Justin Baldoni and the Wayfair parties, whom she views as victims of this alleged smear campaign. She highlights Baldoni was unfairly cast as the villain in a scandal he had no role in. Her analysis contends the media, particularly the New York Times, became a willing accomplice in an orchestrated scheme where Blake Lively, supported by her PR team, actively worked to shape the narrative in her favor, regardless of factual accuracy. This narrative, Lady C argues, was designed to serve those with the greatest influence, rather than present an accurate account of events. The implications for journalism are vast.
For them to double down on their beliefs that they did the right thing versus admit defeat.
Lady C further underscores the gravity of the situation, arguing the New York Times was far from a neutral observer. Instead, it actively participated in amplifying a biased, one-sided story that severely damaged Justin Baldoni's reputation. This perspective vividly highlights the broader problem of media manipulation in high-profile legal battles, demonstrating how easily the press can be weaponized by influential figures with resources to control the narrative. The fallout isn't just intensely personal for Baldoni, it erodes fundamental public trust in journalism, leaving audiences with a dangerously distorted view of reality. The consequences extend far beyond one lawsuit.
For example, in both the article and video, the New York Times presented as unquestioned fact the false and defamatory claim that the Wayfair parties orchestrated a smear campaign, citing to thousands of pages of documents it had reviewed, and claims that the text messages show that the Wayfair parties had engaged in the wrongdoing of which Lively accused them.
Brian Fredman's team is pushing relentlessly to ensure the New York Times is held fully accountable for its alleged actions. They argue that when a media outlet wields such immense power to shape public perception, it carries an equally profound responsibility to ensure accuracy, especially when individuals' lives and careers hang precariously in the balance. The Times has long presumed itself beyond accountability, but this case directly challenges that perception. Fredman's compelling argument suggests that even the most powerful media institutions must face consequences when they allegedly abandon journalistic integrity for a sensational, predetermined narrative. No one, it seems, is truly untouchable.
Here is not everything that was in the New York Times made its way to the complaint. And I guess you would look at that and say, well, maybe Lively and her lawyers wanted to include more that wouldn't have to stand up to rigorous defense in the legal.
This escalating legal battle between Justin Baldoni and the New York Times isn't just a celebrity defamation suit, it's a seismic clash over journalistic ethics, accountability, and the very definition of truth in the digital age. It asks whether powerful media outlets can deliberately manipulate narratives, break promises, and ignore facts without severe consequences. The outcome will not only determine Baldoni's future, but could reshape how the public views media integrity. It's a stark reminder that even giants can be challenged, and that the relentless pursuit of truth, regardless of power or influence, remains humanity's most vital endeavor. The world is watching, waiting for justice.